Good afternoon, everyone. My name is Jeremy Herman. I'm an employment lawyer at Samfiru Tumarkin LLP. I'm located in Toronto. As you know, we do many of these sessions every week, these live stream sessions, and we do them across our offices in Toronto, Ottawa, and in the other provinces that we operate, including British Columbia and Alberta. And the goal of these sessions is I always explain is to answer your questions, get your employment law questions answered. I'm here right now live to answer those questions for you. Please don't be shy. Don't hesitate to ask your questions. This is a free and very useful opportunity to learn more about employment law, and I urge you to take advantage of it. Now, before we go into answering your questions, I always like to start off with hot topics in employment law. And the topic I'm going to talk about right now is whether employers are able to prevent their employees from taking on side gigs. Can they work in side hustles while they're working for a company? And before I go into this a bit, I want to distinguish between working in a side gig versus being banned from competing against your employer after your employment ends. So when you work for a certain employer and then your employment with that employer ends, that employer might say you are banned from competing with me. Now, that's in other words called a non-competition clause. And recently, the past couple of years, those have become banned in Ontario. And even before they were banned, courts really did not like those kinds of clauses. They found them too restrictive on people's trade. But what I want to talk about now is during your employment, can you engage in a side hustle? Can you do a side gig? And the short answer is an employer can prevent you from engaging in a side hustle. You can sign an employment agreement that says that you, as a non-unionized worker, cannot take on any side gigs. You have to devote your full attention and time to working for me, the employer. And that is legal to do so. And so that's important to note. We're living in what's called a gig economy, where many people are earning income through multiple gigs or multiple hustles. And so it's important to note that you might want to check out your employment agreement. See if your employment agreement actually allows you to work for another employer while you're working for one employer. They may not, one employer may allow it, the other one may not. They both may disallow it. And so it's important to understand those issues. I actually wrote a blog on this piece, and you can find it on our website. It was just posted a few days ago. So I urge you to check that out. You can learn more about all of these topics, as you see on the screen, at employmentlawyer.ca. And let's now delve into questions. So we have a question from Draymond on Facebook. Draymond asks, my company closed back in August. The business appears to be shut down, but am I still owed severance? So let's assume that the company is still operating in the sense that they're not bankrupt. So they haven't initiated any bankruptcy proceedings. Let's put that issue aside because that severely complicates the matter. If you are working for a company and the company shuts down, you are still owed your severance. So if you are being let go because the company has shut down, even if they haven't shut down, you're owed your severance, and the issues don't change. You're owed your full severance pay no matter what. There could be situations where your company is sold to another company. In that case as well, you are owed your full severance pay from the company that is sold. So if you work for the seller company, that company owes you your full severance pay, not the company that bought the selling company. It could be that you're offered a new employment opportunity at the new company, at the purchasing company, and that might impact your full severance entitlements if that is a very comparable job. So let's say you work for company A is bought by company B offers you a new position. And if that position is very comparable in terms of pay, in terms of duties, in terms of work location, etc., to the job that you perform for company A, then you arguably have a duty to accept that position. And it would impact your full severance pay if you don't accept that position. Doesn't change the fact that you're owed your minimum entitlements, though. So you have minimum severance entitlements, and that is owed to you no matter what, even if you're offered a new job by the purchasing company, by company B, and the company that owes you those minimum entitlements is company A. So I hope that explains the issue, Draymond, and if you have any follow-up questions, please let me know. Post them in the chat. Okay, let's move on. We have a question from Tina on YouTube. Tina asks, I was on a 1-year contract that was extended twice for 6 months or so. However, in the last few months, my hours have been drastically reduced from 40 hours a week to almost half that. I know I'm on contract, but is there anything I can do? Okay, so great question. There's a few issues at play here. Let's put aside for now the issue about your hours being reduced. If you are on a 1-year contract, that's what's known in law as a fixed term contract, right? You're on contract for a fixed term period, and that period in this case is 1 year. And it's very common for employers to offer fixed term contracts. And then at the end of the fixed term, they extend that contract. In this case, Tina says that they extended it a few times. So in the event that Tina is terminated, Tina is likely an indefinite term employee. So what that means is that even though there were multiple fixed term contracts, there was a series of them, started with 1 year, and then it was extended for 6 months, and then 6 months again. And certainly if it was extended for multiple times beyond that, then she would be considered on an indefinite term. She would be considered an employee who's worked for an indefinite term, and that is how her severance would be calculated. It wouldn't be any different from an employee who was never on a fixed term contract. They were on an indefinite term contract. They're terminated from their employment, and their severance is calculated based on that. So the point is that just because your employer has made you sign multiple fixed term contracts does not mean that the law would actually consider you to be on a fixed term contract if you're terminated. The law might consider you to be on an indefinite term contract. That's one issue, and it's a fairly common issue. Getting to the second point of what Tina asked. So Tina says, can my hours be drastically reduced? The answer to that is no. So whether or not you're on a fixed term contract or an indefinite term contract, if your hours are being drastically reduced, that is likely a constructive dismissal, a dismissal of your employment. So let's go through what a constructive dismissal is according to the law. So what it is a fundamental change, substantial change rather, to the fundamental terms of your employment. So in this case, the term of Tina's employment is that she works 40 hours a week. Now the company comes along and reduces that significantly, right? If the company says you're working from 40 hours a week to now working 20 hours a week, that is a substantial change to a fundamental term of her employment, which is her hours of work. And she can treat that change as a constructive dismissal, which means that she'd be entitled to her full severance pay, just as if she had been terminated by her employer. Now, there are other types of constructive dismissals, right? And it's important to go through them. So it could be a change to hours. It could also be a change to your compensation or to the duties that you perform or your work location. All of these things, if they're substantial, then they're considered a constructive dismissal of your employment, and you should absolutely contact us because you are likely entitled to your full severance pay. Now, I keep saying full severance pay. It's important for you to note how severance is actually calculated. So we have a very cool tool known as the Pocket Employment Lawyer. Part of that tool is a severance pay calculator. The severance pay calculator allows you to find out how much severance you are owed based on your particular circumstances. So severance is calculated based on one's age, one's length of service, one's position, one's compensation package, and generally speaking, the availability of similar employment opportunities in the job market. Our severance pay calculator will ask you all those questions. How old are you? How much were you earning? What position were you in? And they will then, the calculator will then calculate how much severance you're owed based on those circumstances. It's a free tool. It's anonymous. You can use it whenever you want. As you saw on the screen, just go to pocketemploymentlawyer.ca and you can find the severance pay calculator. I urge you to use it whether you have been terminated, haven't been terminated. You might be working for a company, you have no idea whether you're going to be terminated, and you just want an idea of how much severance you would be owed in the event that you are terminated. Very important for you to understand that. Okay. We have another question from Stephen on Facebook. And Stephen asks, if your manager has put you on a PIP, performance improvement plan, does this affect your severance package if let go? Typically not. So if you are let go, even though you were put on a performance improvement plan, if you were let go without cause, then it doesn't matter. You could have been put on a performance improvement plan, not put on a performance improvement plan, and you'd be owed the same amount of severance. Now, even if you were let go for cause, which means in this case, the employer would be taking the position that as a result of your poor performance, which is why we have to put you on a performance improvement plan, we're terminating you without any severance because we have cause for termination. In that case, it is very unlikely that your employer is going to be able to withstand the law in that regard. The law will say that the employer cannot do that. The employer cannot terminate you for cause simply because of poor performance. First of all, it may not even be true that your performance was poor. And even if it is true, that is usually, in most cases, not a sufficient reason to terminate you without any severance pay. So if you've been put on a PIP and you've been terminated without cause, contact us. Even if you've been terminated for cause, don't think that your employer can necessarily do that. They usually cannot do that, as I've explained. So please contact us in that regard. And you are likely owed your full severance pay, even though your employer's taking the position that you're not because they think you were performing poorly. Okay, Stephen, if you have a follow-up, as usual, please post it in the chat. Okay, we have another question from Kathy on Facebook. Kathy says, my original employment contract says that I must be available 24/7, 365 days. I have been in my position on day shift for 17 years. There is no union. If I were to switch departments to change jobs, I go to the bottom of that seniority list in that department. That could mean I can end up on a grave shift. What do you think of this? Well, you can do what you want, Kathy. And what I mean by that is if you want to switch departments, even though it might put you on the bottom of seniority list in that department, you are free to do so long as your employer is offering that to you or is permitting you to do that. It's a different situation, though, if you're not willing to do that, but your employer is making you do that. So, Kathy, if your employer is telling you you have to switch departments, and that could impact that will impact your seniority, and if it certainly impacts other aspects of the terms of your employment, perhaps your pay, perhaps where you work, perhaps your shifts, like you said, you'd end up on a totally different shift. That would be another example of a constructive dismissal. Your employer is implementing a significant change to terms of your employment that you don't agree with. So if you propose it and you want it, despite the fact that there are some downsides to that, then it's not a constructive dismissal. But if your employer is imposing it on you and it's not something that you don't want to switch departments, you don't want to change your shifts, you don't want your seniority to be reduced, then you don't have to agree to it. And that would be a constructive dismissal. And you should certainly contact us about that, Kathy. One thing I'll note is many questions today about a constructive dismissal situation. There's one situation where an employer can change the terms of your employment, and that's if your employer is allowed to do so according to your employment agreement. So very important that we review your employment agreement. Kathy and anyone else who thinks they might be constructively dismissed. It could be that your employment agreement allows your employer to do things. So one example we see all the time is a layoff. So not a termination, but just a temporary layoff. Many new contracts, new employment contracts, allow the employer to temporarily lay you off for a certain period of time. If the contract is drafted in a proper way, in a manner that's enforceable, your employer is allowed to temporarily lay you off for a certain amount of time. If the contract doesn't say anything about temporary layoffs, then you can treat a temporary layoff that's imposed on you as a termination. That would be a constructive dismissal. So really, it depends on what is written in your employment contract. Now, again, I note that the contract has to be drafted properly and enforceably. So if it isn't, even if it has a clause that says that your employer can lay you off or can implement changes to your employment, it could be that the contract is still unenforceable, in which case you can pursue a constructive dismissal and obtain your full severance pay. So don't just assume if you look at your contract and you see some language in there that says your employer can implement changes to your employment, don't assume that you're dead to rights. You might have some leeway there, and you should still set up a consultation with us, allow us to review the employment contract, because we could perhaps find a way to argue that the employment contract is not enforceable, in which case you can challenge the changes to your terms of employment that your employer is imposing on you. Okay, Kathy, I hope that sufficiently answers your question. If you have a follow-up, please let me know by posting it in the chat. We got many questions today, and I'm happy to see that. So let's move on to another question from Jay on YouTube. If a company hires on new employees that have no experience and expect you to help train them where you hadn't trained before, is that a fundamental change? Likely not. If, let's say, for a certain period, maybe a week or something like that, your employer is asking you to assist with helping train new employees, it's going to be difficult to argue that is a significant change to the terms of your employment, and therefore you're constructively dismissed. Now, if this goes on for a very long period of time and you're prevented from doing your work or performing properly at your duties, and potentially there's an issue there, a legal issue, and you should let us know. But if it's in the normal course, just some hours or days or weeks of helping train new employees, then I think it would be difficult to argue that you have been constructively dismissed as a result of that alone. Okay, Jay, if you have follow-up or more information to provide, you could post it in the chat. Okay, moving on, we have another question on Facebook from Melody. I was informed a month before my mat leave ended that I was being let go as my role was redundant. I was not offered anything other than the minimum 2 weeks, even though I'd been at this job for over 6 years. Is that right? No, that is not right. If you've been in a job for 6 years, first of all, you're owed much more than 2 weeks of pay. You'd be owed more in the range of maybe 6 to 8 months of pay. Depends on other circumstances, of course. It depends on your age. It depends on what position you were in, how much money you were earning, etc. But 2 weeks is certainly not enough. It's not even your minimum entitlements under the Employment Standards Act. So certainly a legal problem there. A different issue I also see potentially is that you were let go during your mat leave. So the law says that your employer has to reinstate you into your position or a similar position after a protected leave. Mat leave or parental leave is a protected leave. And so that could also potentially be a problem legally. There could be a human rights case here if potentially you were let go as a result of the fact that you were on mat leave. That is discrimination under the Human Rights Code, and you'd be entitled to also human rights damages in addition to your full severance. So Melody, there's a lot at play here, as you can tell. Certainly legal issues here. Let us know. Contact us at help@employmentlawyer.ca, and we'll set up a consultation, and we will go through these issues with you, because there are certainly many issues involved here. Okay. We have another question from Zara on YouTube. Zara says, can I get severance pay even if my employer does not have more than 2.5 million payroll and working in the company for only 1.5 years and just let go without cause? Yes, great question. So severance is a word that we use colloquially. It's different from what Zara is talking about, which is what's called statutory severance. I don't want to get too deep into the weeds here with this, but to explain it simply, the Employment Standards Act permits you or entitles you to get statutory severance if you worked for a company for more than 5 years and the company has a payroll of over 2.5 million, as Zara says in her question. But even if you did not work for the company for 5 years, you are still entitled to severance pay, generally speaking. So as I say, severance pay is also a colloquial term. So assume that you are still entitled to severance pay based on the factors that we've gone over today: your age, your length of service, your position, how much money you were earning. All of those factors would dictate how much severance. And yes, you are still owed severance, even if you are not owed statutory severance under the Employment Standards Act. So I hope I just explained that in a clear way. Either way, Zara, yes, you're owed severance pay. You can absolutely contact us. My contact information was just on the screen. You can use that, and you can contact me directly if you'd like, or you can contact us at help@employmentlawyer.ca. Okay. Another question we have from Vote PTI on YouTube. I'm facing harassment from my manager since I returned from parental leave. Harassment such as being told to quit, being accused of something I didn't do. Today I was sent home early. Definitely a problem. So harassment is not permitted. Your employer cannot harass you. You can also treat that as a constructive dismissal. Your employer, it's a term of your employment that you're treated well. And so if you are not treated well, if you're harassed or you're being subjected to a toxic work environment and you can show that, you can prove it, then that could be a constructive dismissal of your employment. Now, if it is related to your parental leave in any way, that is also discrimination under the Human Rights Code. So multiple issues going on here. And it's important that you deal with this. Don't just let this go. Don't do nothing about it. Don't do nothing about the fact that you were sent home early or about the fact that you're being harassed. You want to challenge these things so that at least your employer stops doing it, or you are or you're treated properly and you are terminated and you receive your full severance pay, and treat this as a constructive dismissal. So at the very least, these issues go away, and perhaps you treat your employment as having ended as a result of all of these issues, and we will help you get your full severance pay in that case. Okay, so I hope that's helpful. If you have a follow-up, please post it in the chat. Okay, we have a question from Wendy on YouTube. Okay, question regarding maternity leave. Increased pay for the 9 months. When she returns, do I go back to the same wage I was at before I covered her mat leave? Okay, so I'm not fully understanding your question here, Wendy. I think I'm missing some details. So I definitely encourage you to contact us at help@employmentlawyer.ca, and we can gather those additional details from you and set up a consultation. From what I could tell, you might be covering a maternity leave, or you're on maternity leave. I'm not 100% sure. One thing I can say for sure is that if someone's on a parental leave or a maternity leave and they come back to work, they have to be provided with the same wage. And if there was a increase in the wages during the time that that person was on parental leave, they have to also, that wage increase has to apply to that person. So they can't just revert back to their original wage. Okay, Wendy said she's covering the mat leave. So the person that you're covering for will get their job back. and they have to be provided with the same wage that they were provided with before. I hope that answers the question. If you have more details, I'll try to get to it. Otherwise, please contact us at helpanemploymentlawyer.ca. Okay, we seem to have another follow-up from Jay. There's been a high turnover lately, leading to more net hires, many with no experience. They are not threatening to terminate me, but it's never really been my job to train new hires. I understand that. I understand that it's not your job typically to train people. You may not have done that in the past. So like I said, Jay, if this goes on for a long period of time and it actually impacts your ability to also perform your job, the duties of your job that you are used to doing, then that could be a problem. But typically, if an employer is asking an employee to help train another employee or a couple of employees, and it doesn't really drastically change the nature of your work, then it would be difficult to argue that that is a constructive dismissal. Okay. Another example of a constructive dismissal, once we're on the topic, is a demotion. So if your employer demotes you to a lesser job or a lesser amount of pay, that would be a constructive dismissal. Again, note though that it depends what your employment agreement says. If your employment agreement allows the employer to implement these substantial changes to the terms of your employment, then it may not be a constructive dismissal, even if you don't like it, right? Now, if the demotion is also very minor, it barely impacts your compensation or your title, you're also going to be hard pressed to argue that that is a constructive dismissal. We're talking about pretty substantial changes to the terms of your employment. However, you may not know what is considered a substantial change, and that's why you have to contact us. Let us help you with that. You may not be sure. Is a $10,000 decrease to my pay substantial or not? Well, it depends. Is a percentage decrease to my bonus, is that a demotion? Potentially. It depends what percentage that is. It depends how much money that is. So contact us and allow us to assist you further in this regard. And again, let us look at your employment agreement. Let's see if your employer can do this in the first place. Another topic to discuss is the idea of financial difficulty for an employer and how that impacts severance pay. So just today, I got a response from an employer. I'm acting for an employee, so I'm representing an employee, and that employee is entitled to severance pay. They've been terminated, and the employer has responded saying, look, through COVID, the company has gone through a really difficult time. It's even more challenging now with high interest rates, et cetera. Therefore, we can't pay the severance. So that is not legal. Your employer has to provide full severance pay, despite the fact that they're going through financial difficulties. It's unfortunate that they might be experiencing those financial difficulties, but it doesn't change the employee's right to severance. So for example, a good example is the tech industry. Many employees are being laid off in the tech industry. And a lot of the time it's due to financial difficulties that the employer is facing. But then think about it from the employee's perspective, because they're now they work in an industry that is difficult to get a job now because there are so many layoffs. So if the employer were allowed, because of their financial difficulties, to not pay full severance to the employee, well, now the employee is severely worse off, right? Because it's going to be difficult for them to find a new job given the industry, and now they'd be left with limited severance pay. So just important topics to think about. They affect many people today. And so I hope that was helpful. I hope the entire session was helpful. I will be back with you again in a couple of weeks. I always look forward to it. And we're back live tomorrow at 1:30 p.m. as you see on the screen with my colleague, Dan. So we hope to see you there, and take care. Have a good rest of the day.